Welcome everyone to our quick tracer update on ICANN79. What happened and what's next? With me is Mason Cole, our internet expert. Mason is the internet governance advisor for Perkins Coie. He's been involved in internet domain name expansion, issues management, and brand protection for more than 20 years. A recognized leader in internet governance, he serves as chair of ICANN's business constituency, where he is a vocal proponent of responsible policy development for business users and brand owners. Next slide. Okay, there were several topics that were trending at ICANN79. The ones that we would like to highlight here are the WHOIS registration data request service. We're also going to get into tackling DNS abuse. That was a big topic of discussion. And then also NIS2, the transposition of NIS2 directive in Europe. Okay, Mason.
Okay, thanks, Faisal. Good afternoon, good evening, good morning, everyone. Mason Cole here. Pleasure to be with you all. We have quite a bit to talk about today, so let's dive right in. So if you're a brand owner and you're interested in WHOIS data for whatever reason, for brand protection or to make sure that you're guarding against DNS abuse or anything else, then you're interested in what's known as the RDRS, which stands for Registration Data Request System. You see on the screen there a link to the RDRS, which is hosted at ICANN's website. ICANN, of course, being the organization that oversees the security and stability of the domain name system. And ICANN has established the RDRS as a ticketing system that, in essence, funnels WHOIS disclosure requests to registrars that are participating in RDRS. So you need WHOIS data for a particular reason. You go to RDRS, you submit your request for disclosure of WHOIS record, and ICANN funnels that request to the registrars that either are participating or are not participating in RDRS. The system has been operational since November 28th. Well, there's a typo on the screen there. It's actually November 28th of 2023. I'm sorry, of 2024. So we've got what we have is an operational system that's been in place now for about 2 or 3 months. And the objective that ICANN has stated for RDRS is that it's a measurement of marketplace demand for registration data prior to investing in what would be a more fulsome system with mandatory registrar participation. So you would have what was proposed previously as a comprehensive system for submitting requests for WHOIS data into the system, and it would then spit that data back out to you. What we don't have now is a comprehensive system for actually disclosing that data. Requests are then routed to the appropriate registrar for what's known as a balancing test. And then potential action. The balancing test is the registrar determining whether or not the requester is entitled to the WHOIS data behind a registration. So if the registrar decides that you're not entitled to that data, you don't get the data. If the registrar decides you are entitled to the data, then within 72 hours, you are provided with that data. Registrars will then follow up separately to provide you that data. So there are now a total of 72 registrars participating in the system. That's the good news. The bad news is that less than half of all registered GTLD domain names are represented in the system. So when you submit a request for a WHOIS record, chances are fewer than half of those requests are represented in the system, and you may or may not get that data. So it's a bit of a clunky system. We know that. What the objective of what we're trying to do right now is demonstrate that there is actually WHOIS demand in the marketplace and demonstrate that demand so that we can build a more fulsome system within the ICANN sphere for WHOIS data requests. Next slide, please. All right, so what has ICANN produced so far in terms of RDRS metrics? To its credit, we have to say that ICANN is reporting about usage of the RDRS, which is helpful so that we can evaluate the marketplace demand. So for the reporting period between November 28th of last year and December 31st of last year, there were 219 total disclosure requests for the registrars that are participating in the RDRS. Only 15 of those requests were approved for disclosure. 103 disclosure requests were not approved. And you may be asking, well, 103 and 15, that's 118. What's the difference between the rest of the 100 odd disclosure requests? Chances are those were actually just ignored by the registrars and not followed up on. Reasons for denial range, as you see on the screen here, among a number of factors. What ICANN has reported is that 9 of those requests failed to comply with any provision of the RDRS legal terms. Okay, 10 of those were submitted, but contracted parties could not disclose the data due to applicable law. Out of those requests, 29 were either incomplete or more information was required before the request could be processed, or the requester didn't respond to the request for additional information from the registrar. 46 of those requests were returned with a request for other corrective action to be taken before the request could be processed. That's a nebulous concept. There may or may not be instructions included with that from the registrar to the registrant who would say, this is exactly the type of corrective action that you might take. Again, kind of a clunky system. It's not fulsome. We may or may not have complete instructions on what you need to do to follow up on getting the data that you need. And then in 41 cases, there were other non-specified reasons for not fulfilling the request. And then there's a link at the bottom of the slide there that can tell you more about the metrics that we've discussed here on this slide. Okay, next slide. Thank you. So where does that leave us in terms of the requester community? Well, we're in a difficult spot. The requester community is frustrated. They're suspicious. There was the ICANN commercial stakeholder group, which represents the business constituency, the intellectual property constituency, and the ISP constituency. Had a feedback session at ICANN79 in San Juan, Puerto Rico, where there was constructive input supplied to ICANN and to the community about where the requester community was experiencing frustration. So, for example, in terms of disclosure-related issues, requesters experience a very wide discrepancy in disclosure rates for similar requests between registrars. You request WHOIS data from registrar A, and you might get that data without any problem. You request the same type of data from registrar B, you don't get the data. There's too wide a discrepancy between what registrars are supplying and what they're not. Requesters also are frustrated when the data they get turns out to be inaccurate. So we know that the WHOIS database contains inaccuracies. We know that that's been a problem now for as long as I've been involved in ICANN, which is more than 20 years. And so it does little good when you're actually provided the data, but it turns out to be the data turns out to be Mickey Mouse at 123 Main Street, and it's not accurate, and therefore you can't take any action. Some registrars do seem to automatically deny disclosure for specific types of requests. For example, trademark related requests are referred to sometimes to a registrar's own complaint procedure. So you go to RDRS, you file a trademark related disclosure request. The registrar comes back and says, we're not going to disclose that via RDRS. We need you to come to our registrar and make that request via a complaint procedure, which just adds time and frustration into the mix. Some registrars also are denying requests for disclosure, and instead they just take down the domain name. That might on its face appear to be a good idea, because you may have an infringing domain name, or you may have another problem with a specific domain name and the content that's on that name. But when the domain name is taken down and the underlying whois data is not provided, you don't have anywhere to follow up. You just have, you don't have the name of the registrant. You don't have a way to locate that registrant. You don't have any data that you can use to file a UDRP or any kind of enforcement action. So, we're seeing quite a few disclosure related issues here with regard to the RDRS that are going to need correcting over the long term if it's going to be an effective system. All right, next slide, please. Okay, so if you're a brand owner, what should you do? Well, even though I've been complaining now for the last few minutes about RDRS, the fact of the matter is you should use the RDRS, because the immediate priority is to demonstrate user demand for whois data. What we don't want is for, at the end of this experiment, which is going to last for approximately 2 years, we don't want ICANN to come back and say, you know what, nobody uses the system, therefore there's really no demand for whois data, and so we don't need to build a more robust system for disclosure of that data. So it's important that you do use the RDRS. If you don't want to use the RDRS directly, enlist a proxy, and Tracer would be a great proxy to be able to do that. So Tracer has the Tracer and similar organizations have the ability to submit requests on your behalf, log those requests within the RDRS, demonstrate demand on behalf of the user community that says, in fact, there is a need for whois data, and then we can build the case over time that whois data is necessary. And then if you're so inclined, it would be very helpful if, as a brand owner, you could contribute your experiences to the ICANN working group on RDRS. And there is an email address here on this slide that would be extremely helpful if you would contribute to say, these are my experiences as a data requester. Here are the reasons why I'm being denied the data. Here are the reasons why I am provided the data. And here are my frustrations with the system. We can take that impact, or that input, provide constructive input back to ICANN, and hopefully build a more robust system. That's what we're looking for.
Mason, real quick, going back to that slide. The system went operational in 2023, last year in November.
Correct.
And so it's still kind of nascent, and so there are probably going to be some, it's going to get a little bumpy at the very start. So hopefully both the requester community and the registrar community can work things out as we get some traction here over the next few months and over the next year. This is supposed to be a 2-year look at this, right? Kind of a 2-year trial.
That's right. That's right. Yeah, it should go until late 2025. And as I mentioned before, and you're correct, Faisal, with what you just pointed out, what I mentioned before is what we don't want to have happen is for ICANN and the registrars and others to come back at the end of that 2-year experiment and say, well, you know what? There's just not that much demand for whois data, so we don't need to build a whois data disclosure system. And that would be an unfortunate outcome. We don't want that we don't want to have that happen. Okay, next slide, please. All right, topic number two, and this has been a topic for some time in ICANN circles, and that is the issue of domain name system or DNS abuse. And we in the business constituency have been particularly vocal about this for some time now, because DNS abuse, abuse of the DNS and its resulting impact has a defined monetary impact on business users of the internet. It also has a well-defined impact on intellectual property holders, others who have a stake in the use of the domain name system. So when we say DNS abuse, what actually is that? Well, it depends on who's proposing the definition. If you're a contracted party, and by contracted party, I mean you're a domain name registry or you're a domain name registrar. Those parties have done a good job within ICANN to define DNS abuse as phishing, farming, malware, botnets, and then spam as a delivery method for the first four types of abuse. That, of course, is not a comprehensive definition of what DNS abuse is. Other definitions are more appropriately inclusive, so they can anticipate what developing threat vectors might be out there. So we've got sort of a limited definition of DNS abuse, but at least it's a start in terms of what we can do to actually combat a few types of these abuses. Next slide, please. So there have been changes to the registry agreement and the registrar accreditation agreement, which are the authoritative contracts that ICANN uses to manage their relationships with registries and registrars. So these are known as the RAA and the RA. There have been negotiated contract amendments that establish the affirmative duty to disrupt or mitigate DNS abuse, and not merely to take appropriate action, which is what the previous version of the contract asked for. So the changes in the contracts do a good job of further equipping ICANN compliance to enforce against contracted parties that harbor abusive behavior. And it does a better job of enumerating what contracted parties are obligated to do when they encounter DNS abuse. All these are positive steps toward doing something about DNS abuse. These contract changes take effect on April 5th of this year, which is just a few days away. And we're looking forward to seeing what specific kinds of outcomes these contracts have in terms of impacting the problem of DNS abuse. Next slide. So what happens next? So I would say that the business community and the IP community are very satisfied that there have been initial steps taken toward the combating of DNS abuse via the contracts. ICANN and the contracted parties, again, registries and registrars, have committed to ongoing discussions and further action on DNS abuse, either through further contract negotiations or through ICANN policy development. I'll say that we weigh our preference toward contract negotiations because policy development takes a very long time inside of ICANN. But you know, we're going to look for appropriate avenues to do something about DNS abuse, no matter where those avenues exist. But we're hoping for further action on contracts. So what is the community asking for in terms of next steps to deal with DNS abuse? So we mentioned the five areas of definition of what DNS abuse is known for today. But there are other areas where we need some action. And one of those is the ability to act at scale, not just playing whack-a-mole. And by at scale, I mean, for example, the ability to act against abuse at the account level. You may have one bad actor who has registered literally thousands of domain names and is using those in an abusive manner. And instead of tackling each of those domain names one by one, What we're looking for is the ability to act against that actor itself and not against all the domain names, again, one by one. So that in that way, you'll be able to cut out a swath of abuse in a much more efficient manner. We're looking for the ability to address what's known as CSAM, child sexual abuse material, which is obviously a repugnant problem in the DNS. We're looking for the ability to document to an abuse reporter on the steps taken to mitigate reported abuse. So you're reporting abuse, you report that to the registrar. What we're looking for is the registrar to come back to you and say, this is what we've done to address the abuse that you reported, and not just have that disappear into a black hole. We're hoping for improvement of response timeframes to match the urgency of threats. Right now, it may take days or weeks for a registrar or registry to act on DNS abuse. We're looking to shorten that timeline. We're hoping for the requirement that who is revealed to the reporter when abuse does occur, so that the reporter can take action directly against the offending party. We're hoping for reconsideration of what is common in the industry right now, which is the ability to register domain names in bulk. There are registrars who provide the capability to register tens, hundreds, even thousands of domain names at one time. And those are known, that capability is known to play into the favor of abusive registrants who register thousands of domain names at a time, spread malware or botnets or what have you across all those domain names, and then quickly take those domain names down, register another 1,000, do the same thing. We want the ability to try to prevent that. And then, excuse me, we're also looking for a responsible pricing strategy. We know that registrars who provide names for very little money or even free tend to attract bad actors, and we're hoping for responsible pricing strategy on the part of registrars to help mitigate that. Okay, next slide. Again, here, what should brand owners do? It's important that you continue to monitor abuse-related developments. Advocate strongly for further contract changes within ICANN. If you're not if you're a brand owner and you're not part of the intellectual property constituency or the business constituency, I encourage you to either join or liaise with those groups so that your interests can be represented in front of ICANN as we consider these kinds of changes. Okay, next slide. Okay, back to you, Faisal.
Thank you, Mason. So this is the third topic that we were going to address, and a main topic at the ICANN79 meeting. So NIS2 is, at the end of the day, EU legislation that is primarily focused on addressing cybercrime. Now, people have heard of NIS2, they've heard of GDPR. The difference between NIS2 and GDPR legislation is that GDPR was enacted to strengthen data protection and individual privacy rights in the EU, while NIS2 seeks to improve the security and resilience of network and information infrastructure across the European Union. So the idea is to help organizations defend their information systems against threats like phishing, malware, and unauthorized access. Now, NIS2 also seeks to fix some of the perceived flaws in the original NIS directive and broaden its scope as well. Now, how is all of this relevant? One of the things that NIS2 sought to do, and one of the other things it sought to do, is to also clarify some of the issues resulting from GDPR, the outcome of which was the restriction of access to whois, which occurred after its enactment. And that's our Article 28. Now, how does NIS2 do that? And that's the next slide. So it clarifies treatment of whois as follows. It requires the accuracy and completeness of data. It demands validation of data. It sets 72-hour response timeline for disclosure of data to legitimate requesters. It differentiates between legal and natural persons, and it mandates data access free of charge. Some registrars have been charging for the data. So now it's requiring that that data be provided free of charge to the requester. Next slide. So where are we at now with the status of NIS2 implementation? So member states now have gotten this directive, now have to transpose that directive and implement it as jurisdictional law. Now, it's going to happen in a couple of different ways, right? Some of the jurisdictions, and the 27 of them, are going to transpose it in a word-for-word manner, directly as set forth in the directive. But there's some other jurisdictions that may add restrictions. For example, who has access for law enforcement authorities only may be what they may require, right? So there may be other restrictions that come in. So we're yet to see that. The implementation deadline is going to be October 17, 2024, and it's likely that there may be some jurisdictions that might miss that deadline. ICANN is leaving the compliance issues strictly to the contracted parties at this point. So ICANN is going to step out of that compliance area. Next slide. So we'll see what happens in October and where we're at. But at this point, I mean, I think it's important that if you want to know more about it, you want to participate in what's going on, you can participate through the trade associations such as INTA, that's very active in this space, and you'll be able to gather a lot more information about what's happening and the transposition of that directive by the member states. And if you're in Europe, you can participate in jurisdictional consideration of Article 28 and make your feelings known. We put the link directly there, and you can actually reply to open comment periods that are outstanding at this point. And I think that is it on the three topics. Thank you everyone for joining us for this quick update of the ICANN79 meeting and what's happened and what's next. And we hope to see you again next time. And thank you, Mason, for participating here. And thank you all.
Thanks, everybody.